second. I'm gonna hit record because otherwise I'm gonna forget because I'm like Dory the fish. And then I'm like, oh no, I forgot to record. Okay, so I'm very excited because this week is, and you guys are gonna hear me say this a lot, but I do feel this a lot. This is one of my favorite weeks to lecture because the cases, the history behind the cases are so fun. Again, these cases don't make it to the Supreme Court because they're boring. They make it to the Supreme Court because we have people involved and people make mistakes and people are complex creatures, right? And so the stories behind them, I think you're going to love. And so before we do that, though, we have a couple things for housekeeping purposes that we need to go into. And let me move this up a little bit. So, do you guys remember when I said not to use filler words? And I told y'all, I said in my first lecture that I was going to give y'all the face if you did, and many of you guys did, right? So you're getting the face. So I'm going to reiterate it because it is so important, and I really can't emphasize that enough. You guys really have got to start using, and I'm not saying everybody, so I'm not like pinpointing one person in particular at all, because there's quite a few of you on this first assignment. But a few things moving forward, because each week you should be taking my feedback and some of the suggestions and just getting better and better and better every week. Because the goal of this class is to help you guys become better legal writers and scholars, right? And one of the things that I want to see is I want you to be more confident in your writing. And I can see it in your writing that you're not there yet. And that's to be expected because we're in the first week, right? So I'm not worried about this yet. A lot of you are like, I don't know what to say yet. And that's totally understandable. Okay. So I want you, though, to pretend like you do, right? There's that saying, fake it until you make it. I'm all for that. Pretend like you do. Okay. So be more confident in your writing. And part of that is instead of saying, I think, or I might, don't say that. Again, if you were to get in front of a judge and say to the judge, Your Honor, I think you're already dead in the water because everybody in that courtroom has already lost faith in you. Your client has lost faith in you. You need to be confident. And so we don't want to hear you say, I think, or I might, or I would advise. Omit that for several reasons. One, it weakens an otherwise strong statement. Second, it's a filler word and it takes up a lot of space. Think about this first week, you only had 50 words. And by saying, I would advise, you've already lost 3 words. Okay, so just knock that out and just state what you advise, right? Just get to the meat of your argument. Oh, and that brings me to something that I forgot to put on this PowerPoint slide that I also want you guys to take into consideration. Some of you, not a lot, but some of you didn't get to your argument, your position until your conclusion. So you put all your rationale, you'd state, I'm trying to think of an example. Um, you'd blah, 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 blah. You say national power structure would benefit a newly formed government because da 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 da. A regional power structure would not, and then you'd give like a little quip, and then at the end you'd say, so I think maybe having a mix of the two would be a good approach. And I'm like, oh, so that's your position. That should have been at the front. So always in legal writing, your first sentence, and I want your ears to perk up when I say this, your first sentence should always be your argument. Period. The end. You don't want the reader to fish around for where you stand. Your first sentence should be a national power structure is the best approach, or broadly worded protections are preferable to blah, 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 whatever it is, right? Wherever you stand should be first, right out of the gate. And then you explain your why, okay? So that's first and foremost what the way you should lead into your analysis. And many of you guys did that, but some of you didn't. So I just kind of wanted to say that. Now, what was cool is that a lot of you, and this made my heart so happy to see, many of you saw that the answer was not just either or. And when I say this, I'm specifically referencing the first question, the national or the regional power structure. Um, specifically, it didn't have to just be regional or national, it could be both, which was an indication of, drum roll, federalism.
Federalism.
Yes, exactly. See, and this just makes me just do a river dance inside because that shows me you're already absorbing some of these concepts. And it also shows me that you're thinking outside the box, which is awesome, which is super cool. So keep that up. So the takeaway for a lot of this is remember, be more confident in your writing, omit the filler words, say what you think versus prefacing it, and think outside the box. Now, this next statement that I'm saying, I don't say this to be mean, okay? But Dr. Helgi and I don't care about what you ultimately think. And I'm going to say that again, and then I'm going to explain what I mean. We don't care if you think a national power structure is better than a regional one, or broadly worded protections are preferable to no worded protections. We don't care about your ultimate conclusion. What we care about is how did you get there? Okay. So I had some of you email me and you're like, is this the right answer? And my response was maybe. And I hated to say that, but the answer is maybe. We don't care about what you ultimately think. We care about what was the path, what was the logic that you took to get there. That's what we want to see. Because again, you could come, my position internally, and again, my opinion, you will never, ever hear my opinion in this class. And I'm going to say that again because my opinion does not matter. It is not the law according to Shaw. If it was, everybody would be eating Whataburger and having an amazing day every day, right? But unfortunately, that's not the way the world works. It is not the law according to Shaw, it's the law according to the United States Supreme Court. And so that's what I focus on in this course. And so, with that being said, you may see a way to handle the case law in a way that maybe I didn't think about. And you may be really creative in the way that you incorporate case law or tie them together. And that's fantastic. But again, we don't care what you ultimately conclude. We care about how you got there. So I just want you guys to take that into consideration. And I don't want you guys to think, oh my gosh, is this what she wants or is this what he wants us to say? And the answer is no. We don't want you to say one thing or another. We just care about how did you get there. So that hopefully will make you feel a little bit better. Now, I said this in my feedback to quite a bit of you. And this did not count against you, by the way, in this first week. I just kind of wanted to give y'all a friendly nudge moving forward. But I want you guys moving forward to start incorporating some of the readings into your responses. And some of you already did this, by the way, which was awesome to see. But moving forward, you should start practicing this. So you might say, as mentioned in Federalist Paper number blah, or you might say in Marbury versus Madison, blah, whatever it is. So just kind of start doing that as an ear marker, showing us where your logic comes from. So it's not just your opinion, it's your position based on a solid piece of foundation. Billy said, you can use mine as an example. Awesome. Thank you, Billy. And Corinthia said, it's like arguing in a court. You're just trying to plead your case. Both sides trying to plead their case. Exactly. Absolutely. That's a very, very good point. You guys are very good. And then, of course, this is your assignment this week. Now, there's one thing I saw some people do, and I looked through the list, and I don't think any of you guys did this, but if you did, that's okay. I'm not calling you out. But some students actually try to tackle answering both questions. I'm going to strongly encourage you to follow the directions. And when you're told to answer just one, answer just one. Okay, so this week you're told to answer one under each part. So you have a choice of choosing question one, two, or three under part one, or under part two, choosing one, two, or three. So you're basically answering two questions in total. Do not tackle more than that. Now at the top, it says limit your response post to 100 words total. That means that your response to question one And then to part two, okay, should be no more than 100 words. That means you can break it up into 50 words response for part one and 50 for part two. Or if you want to break it up into, 40, 60, that's fine too. But it should be no more than 100 words total, not 100 words per question, but 100 words total. Okay, I'm going to say that again because I always get questions about that. So you can break it up into 50 for part one, 50 per part two, just as long as it doesn't go too much over 100. Again, if you're a little bit over, that's okay, but I don't want to see like 150 words or 180 words. That's a bit over, okay? And this week it will start to matter. So try to stay as close to 100 as possible, okay? So before I go any further, does anybody have any questions? And this gives me an excuse to drink some coffee. And I see I do have a question. Billy said, do we separate the questions? And the answer to that is yes. And great question, Billy. Thank you for asking that. A good way to handle that organization is you can put part one, and then you can designate which question you're responding to under part one. So you don't have to type out the whole question. You can just put part one, and then if you're answering, let's say question two, put question two, and then your response, and then part two, and then let's say you're answering question three, put question three. Does that make sense?
Yes.
Okay, great. Thank you for asking that.
When we list part one and part two, can we, that's not a part of our 100 words, correct?
Oh, no, that's not a part of your 100 words. No,
Okay.
that would be cruel. And then Brian asks, is word count important on the comments to others' posts? No, it's not. Where the 100 words does not count on your classmate responses. And to that point, the majority of classmate responses this first week for y'all's group were phenomenal. There was only like a small handful that I corrected, and by corrected I mean they were cut off too short, meaning they said, "Hey Tim, good job," and that was it. And I was like, "Well, that's great that you're positive, but take it a step further and tell your classmate why it was a good job, right?" But the majority of you didn't have that problem. So I don't even really want to waste too much time on that. But just make sure that you're not cutting yourself short. But no, there's not a 100-word limit on classmate post. And then Carla asked, should that be included as the 100-word count? When you say that, Carla, what are you referencing? I just want to make sure I'm answering your question.
The part one, part two label of the discussion questions.
No, that does not count. So when you put part one and you put, let's say you're answering question one, part one, question one, that doesn't count toward the word limit. Only your response counts towards the word limit. And then just to let y'all know, Cora put the GroupMe chat link in the chat. So if you want to join it, that's a great thing to join. Okay. So I'm going to go forward because we have a lot to tackle today, but great questions. And again, if you have any other questions that you want to ask, just throw it in the chat. All right, so we have some phenomenal cases this week. Again, some of my favorites that I really, really love, including Marbury versus, sorry for that typo, I'll fix that. Marbury versus Madison, not Maryland, typo. And that's where the Maryland comes in. For federalism, if you were to open up a legal dictionary for federalism, the definition would surely point to McCulloch v. Maryland, which is the case that defined that concept. And then congressional power, of course, was allocated in Gibbons, and we'll talk about that. And then federal power was limited in Prince, which is a big deal. And we'll talk about why that was a big deal. And then last but not least, the Hamilton Papers, which are phenomenal. Now, if you haven't had a chance to read any of these, that is okay. But make sure that you do read them because it's important to kind of dive into the verbiage, the language of the court, the rationale, and more detail. What I'm going to give you today is the context, the history, to kind of give you a better idea as to how the court came to their ultimate conclusion, because they didn't just wake up one day and say, we should kind of come up with this idea of federalism. It's kind of a good idea. There's a lot more to it. So without further ado, let's dive in to first some high fives. Now, last week I told you I like to high five long distance the students each week that I find are good representations of A+++s that did exceptionally well. And I also include a screenshot of their post. So that way, for those of you who may not have done as well as you had hoped, you can see what they did exceptionally well and kind of model yourself and their framework so that you can improve week to week as well. So the first person that I want to give a long distance high five to is Joel Vanden Hooten. And as you guys can see, he did exceptionally well. But before I kind of go forward, what do you guys notice about his initial post? What stands out to you?
Excited.
Yes, the very first week, he actually uses quite a few specific references. Articles of Confederation, Federalist 51. He's very concise in terms of his position. So first and foremost, fantastic job, Joel. He did exceptionally well this first week. So long distance high five. And the next one goes to Brian. Brian did exceptionally well as well. So say that 5 times in a row. But he also, as you can tell, cited. But that's not, and I want to emphasize this. This is not the only reason why I chose them as my first long distance high fives. It was also the way in which he phrased his position. He said, answering question 2, named individual rights to be protected, should be explicit within the Constitution as history has proven. Example, King George III, which is great. With the absence of intentionally named protections, rights in fact will be violated. Very succinct, very good position. It's clear. So good job, Brian. And then Sarah also did likewise phenomenally. And she didn't cite anything, so I want to highlight that. But look at the way she phrases her position. Right off the bat, she says a constitutional system should maintain both strong national and regional governments with power divided vertically between them. So this long distance, big heart, because she saw right off the bat that it didn't have to be either or, it could be both. And I knew right from the start, right out of the gate, where Sarah stood with her initial sentence. So I love that. She was concise, she was direct. I knew exactly where she stood from the start. So take a line from Sarah's book and again, tell the reader from the start where you stand. So good job, Sarah. And I saw I had a chat. Yeah, good job, Brian. So again, every week I'll highlight long distance high fives. If you weren't chosen, that doesn't mean you didn't do a good job. We have been a massive group this semester or this term. So there's a lot of you. But I try to highlight as many as I can to show that you guys really did a good job. And for those of you who didn't do as well as you had hoped, you can see maybe where there's areas where you can improve, right? Because I always like having examples. All right, so for a quick R&R recap, repeat, remember, in regards to the question of whether the United States Constitution and whether it says anything about the powers of the Supreme Court in Article 3, the answer is no. It does not specify any specific power. It doesn't say anything about their limits. It doesn't say anything. Does it say who can serve? No. How many can serve at one time? No. How we get rid of one who misbehaves? No. So all of that we have to guide us is in Article 3, Section 1. And otherwise, it is very vague. And again, we see this as a pattern again and again within our United States Constitution. So when we look at this, we see one reference to the Supreme Court. And then in the second paragraph, it says the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, blah, 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 blah. But it doesn't say what good behavior is. And if they violate good behavior, well, how do we get them off, right? What qualifies as a get off the bench type of behavior? Now, pop quiz, and this is kind of a good bar trivia question, or if you want to like bet somebody some money, if you're low on some dough. How many Supreme, and don't Google this, How many Supreme Court justices or justice have ever been kicked off the Supreme Court?
None.
Anybody else?
Two, I believe.
So it's kind of a trick question. Okay, I need a drum roll, guys. Okay, the answer is one and none. Isn't that crazy? Okay, let me explain. So the reason why it's one and none is because our good old friend, which we're going to talk about here in a minute, good old TJ, President Thomas Jefferson, he was not a big fan of the Federalists. And that's like an understatement of the century. And so he was suspicious that there was one Supreme Court justice who was a Federalist. And again, he was mighty mad, as we'll go into here in a second, with John Adams, who had flooded the courts with as many feds as he possibly could. So when he found out that one of the Supreme Court justices was a Federalist, he was like, screw you again. I'm ad-libbing a little bit, guys. He was like, I'm kicking you out. So he kicked him off, right? He said, you're violating good behavior. You're gone. So the guy's like, boo. So he gets off the Supreme Court. Well, then, we have these other branches of government, branches, checks and balances. And they're like, TJ, you can't really do that. So they slapped his wrist and they brought him back on. So again, that's why when anybody asks you if a Supreme Court justice has ever been kicked off the bench, you can say yeah and no. So one and none. Ta-da! So kind of a fun fact. All right. So how do the Supreme Court rulings become the final word? Now, this is a really important question because the Supreme Court really didn't have any definitive role in our judicial system when it was first formed. We knew that we had a Supreme Court, and today we know its role. And I say this kind of with a smile on my face, it's majesty, right? And it holds a very important, prestigious position in our society. They are the final word in any and all legal opinions. But the thing is, that wasn't always the case. Isn't that funny? But here's the kicker. You have to ask yourself, well, how did they become the final word? And the answer is this case, Marbury versus Madison. They gave themselves the power to be the final word. Isn't that kind of funny? So Marbury versus Madison is the coolest case in the world because it is like a soap opera come to life. Again, no case makes it to the Supreme Court because it's boring. Now, Marbury versus Madison all hinges on a very tumultuous time in our political history, and in particular, the presidential election of 1800. John Adams, he thought he was sitting pretty. He thought, without a doubt, that he was going to be reelected. Well, spoiler alert, he was not, right? But he was a staunch Federalist. And he was very proud of all the work that he had accomplished, all the big government things that they had put in place. But the person that had gotten elected was TJ. Remember the guy that we had just talked about that kicked the Supreme Court justice off the bench? Kind of tells you a little bit about him. So Thomas Jefferson, when he came in, when he was coming in, they knew that he was going to disband a lot of what John Adams had put in place, right? So John Adams was having a bit of a panic attack. So before TJ came into the presidency, he did something pretty sneaky. He flooded the courts. He was like Oprah. He was like, you get a judicial appointment. You get a judicial appointment. You get a judicial appointment. Woo! He went judicial appointment crazy, right? As long as they were Federalists. So in total, he put in place 16 new circuit court judgeships and they were all Federalists. But here's the kicker. Back then, of course, I mean, you all know this, there was no email, there was no cars or anything like that. So how did they get their appointments? And it sounds silly, but I want you guys to walk through this with me. Tell the story with me. How did they get their judicial appointments?
It
Bless you,
had to be
Evan.
delivered
And how would they get them delivered?
I guess, by person, by the Secretary of State.
Well, even more basic than that, how would that person get to them?
Horse.
Bingo. Okay, so the person that was supposed to deliver the appointment to poor Mr. Marbury was none other than Mr. Marshall. Now, I want you guys to tuck that fact back in your mind because that's a huge, when I say huge, that is like an enormous deal. Okay, so Mr. Marshall has a judicial appointment. He's on horseback, he's riding, but he does something that history will forever know him for. And to me, it makes him such a lovable human being, but such a jerk because the story goes that he stops off at a pub. And he says something that I think a lot of us have probably said, and it's our famous last words, so to speak, which is he says, I'm just going to have one. Now, have y'all ever just had one when you say you're just going to have one? No. So Marshall gets drunk as a skunk, 3 sheets to the wind, and guess who doesn't get their judicial appointment? Marbury. So Marbury is screwed. He doesn't get it. And guess who comes in the next day as president? Dun, 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 Thomas Jefferson. Now, here's when it gets really wonky. So one of the other individuals that does become a judge, and not just a judge, but a chief justice is, are you ready for this? This is when the soap opera really gets crazy. Marshall. The very guy that got too drunk to get the appointment to Marbury, him. I
Was that
know.
one of Adams' last appointments?
Yep. Bingo.
And
So,
so his Congress was able to pass that, even
mhm.
though because they had
Everything,
to
it was
change,
before
right?
he was passed is the last appointment. So he went through literally as Thomas Jefferson is coming in. So it is official. So the very person that, again, excuse my language, but screwed Marbury out of his appointment is now Chief Justice of the Supreme Court. And it gets even crazier. Guess who Thomas Jefferson's cousin is? John Marshall, the new Supreme Court Justice. And so they hated each other. History tells us that they were not fans of one another at all. And when he was being sworn in as president, John Marshall has the Bible. He's holding it out to Thomas Jefferson. And the story goes that they're just talking trash to each other the whole time. Like, I don't like you. I don't like you either. And so to say that it started off rough would be, again, a gross misunderstatement. So, again, the history, the context of this case is rough. And again, the other thing to take into consideration is at this point, the Supreme Court, and I want you guys to really have your ears perked up when I say this, does not possess the power to make a decision that is the final word. They don't possess that yet. They don't have that definitive power yet. They're a court in name only. Okay? So, with that being said, Marbury is understandably very upset. He wants his appointment to be recognized. And so, excuse me. Let me forward this up a little bit because I can't see. Hold on, let me hide this so that you guys can see the slide. All right. So Marbury actually wasn't the only one to not get his commission. There was actually 4 in total, but Marbury's the one that we know the best. So the justices, they get together, and Marshall was pretty brilliant legally, and that is my opinion. I will preface anything that's my opinion, I will tell you it's my opinion. He was legally very smart, and the reason why I think he was very smart is because he was walking a very fine line. He knew that if he ruled against his cousin, Thomas Jefferson, if he said that Thomas Jefferson had to recognize Marbury's appointment, do you think Thomas Jefferson would recognize or respect the Supreme Court in any way, shape, or form? The answer is no, not at all. Again, they didn't have any definitive power yet. So he couldn't make his cousin mad. But at the same time, he had to also weigh the fact that they were a new court and they had to define who they were. They had to create some type of power, some type of structure, foundation for what they were and what they could do. So the story goes that they went into a cabin in the woods, which sounds kind of like a horror movie, but for them it worked. And Marshall was a drinker, as were many people back in that time period, because the water was so not very clean to drink. And he said, I only drink wine on rainy days. On sunny days, though, Justice Marshall would say, our jurisdiction is so vast, though, that it might be raining somewhere, which I love. And so they drank and they drank and they drank, but eventually they came up with one of the most important rulings in Supreme Court history. Without this decision, guys, we would not have any, and I want to emphasize this, we would not have any of the Supreme Court decisions that we will go into for the rest of this term. This case opened the door to the Supreme Court having any power, any authority, any real weight. So it is massive, okay? So first, they looked at this question: has the applicant, meaning Marbury, the right to the commission? Second, they looked at if he has a right and the right has been violated, is there a remedy? Meaning, can they fix it? And third, if there is a remedy, is it mandamus? Now, hopefully, when you guys read this decision, because it is a very old decision and a lot of the words are very dated, you'll have your dictionary, your Black's Law dictionary, or the link that I included in the last PowerPoint close to you. Make sure that you look these things up, and I'll walk you through this here in a second. But these are the things that they were looking at. And they ruled in regards to the first question. When the commission was signed by the president, meaning John Adams, yes, the appointment was made. So, yeah, he had the right to the commission when it was made. The second, if he has a right and the right has been violated, is there a remedy? And they said, yes, of course he does. He has the right to come to court like everybody else. So is there a remedy? Yes, it's coming to the court. It's coming before us. So the answer is yes. So far, it's yes. Now, the third question, if there is a remedy, is it mandamus? Mandamus is just a fancy word for can we make the new president, meaning Thomas Jefferson, can we make him recognize the appointment? Can we force him to recognize it? Can we make him? And they said, ultimately, no, we cannot. Now, pause for a second. Why do you think that is? Why couldn't they force President Thomas Jefferson to recognize that appointment? What prevented them from recognizing that appointment? What was the buffer?
The concept of checks and balances.
Mm-hmm. Who said that?
Ignacio.
Ignacio, high five. That's exactly right. So, in other words, they said there are checks and balances. In other words, we've got to stay in our wheelhouse. That's not our wheelhouse. We cannot force the president to do something like that. Our job, and this is the big drum roll, this is the big mic drop, our power is to say what the law is. Our job is to look at the Constitution, right, and say what the law is. Now, in other words, and this is the concept that they created, and it's a big, big deal, is the concept of judicial review. Now, remember when I said that they created their own power? This is that moment. This is the moment that the Supreme Court created the power that they possess now that we all take for granted, that we're like, well, yeah, of course they have the power to say what the law is. This is that moment. So they said it was illegal for Madison to withhold the delivery of the appointments. However, it was beyond the power that they had to order him to deliver them. So in other words, judicial review, that concept that I just introduced, it allows the Supreme Court to determine what the law is. They're the final word. That's it. There's nobody above them. And it makes sense, right? If they weren't the final word, a case could go on forever. Now, there's some lawyers that would love that. But there has to be a period at the end of a legal sentence. It cannot just go on and on and on. And they recognize that. But I want to kind of rewind a little bit. Think about the beauty of what they just accomplished. What Marshall did with this is he did not make his cousin mad because he allowed his cousin to win. Marbury didn't get his appointment, but he also won himself, right? Because he also created a power structure for the first time for the United States Supreme Court. So think about that very fine line that he had to walk, and which both sides, so to speak, won. So pretty cool moment in our court history, so to speak.
And he did that by his defining that his role, or the Supreme Court's role, would be to interpret laws
Mhm.
based on the Constitution.
Correct.
And then he said, I have to say this because the Judicial Act of 1789 is actually in conflict with Article 3, Section 2 of the Constitution, and therefore we can't give him the job that he's
Correct.
asking for.
Yes. Bingo. Very, very good. That's exactly right. And then somebody in the chat said, Michael said, outside of the class lecture, what about the other three that didn't get their appointment? Yeah, nobody got their appointment. Again, because it fell in that third issue that they had to answer. Because the first question was, did they get their appointments? And the answer was when John Adams signed it, yeah, they had appointments. But the second question, in terms of, let me go back a little bit. Boop, 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 boop. Oh, sorry. Let me go back. Okay, here he goes. If they had the right, is there a remedy? And then they said, yeah, the remedy is going to court. And everybody has the right to go to court because of due process, right? Remember the Magna Carta. The Magna Carta says everybody has the right to know why they're in trouble and to have their day in court, right? And so they said, yes, their remedy is to go to court. But third, they said, can we force the president to recognize those appointments, mandamus? And they said, no, we can't do that because that's the president's territory. That's not our territory. That's not our wheelhouse. Our wheelhouse is to interpret the Constitution, to say what the law is. We're the final word, where we conduct judicial review. The other aspect, that's the president's position. That's not us, right? So they're forming their own lane and they're saying we got to stay in our lane because of checks and balances. We can't overstep our authority, right? And so, and we're going to see that as a pattern moving forward in many of the other cases as well, is that they do not want to overstep their authority and they want to make sure that they stay in their lane. Their role is judicial review. That's it.
So, do we think that Jefferson thought he won because he didn't recognize that Marshall had created this power center for the court to be able to interpret laws?
That's a great question. What do you think?
I think he was more excited not to have the Federalists put on the bench and therefore didn't necessarily realize the long-term ramifications of what his cousin created by reaching into the Constitution and using the Constitution to say, I can't appoint this person. Sorry. And you win.
I think that's a really good take. Yeah, because I mean, to say that Thomas Jefferson was not a fan of Federalists, again, that'd be a massive understatement. So the fact, as you said, that he could avoid having them on the bench was probably, he was probably doing a river dance of joy. So I'm totally with you on that. It's a really good take. Any other thoughts before we move on to the other case? Oh, and Wanda said, so it's kind of like the way due process works. Absolutely. Absolutely. And it's neat, Wanda, because especially in that case, you see the court try their due process pants on, and I know that's kind of a crude way to say it, but they're like, okay, we know that they're coming to us because they want help. And now it's our job to hear them out because they know why they're in trouble, right? Marbury knows what happened and he wants a help. He wants to be heard. And our job is to hear him. But we can't make this other wheelhouse, meaning the president, we can't make him do something But what we can do is to hear him out and to make sure that the Constitution is followed. That's our wheelhouse. So it's neat to see everybody's role kind of being solidified in these early state, excuse me, sorry, my allergies are going crazy. Solidified. And Farah, that's 100% okay. You're 100% okay. No worries at all. All right, guys. So then we get to move forward with another fun case, and it's where do you find the powers reserved to the federal government? And when you ask that question, I hope all of you, I say this kind of in a funny way, but all of you, when you ask yourself, can they do that? You should instantly look to the roadmap, which everything is in the Constitution, guys. And the place to look is in Article 1, Section 8. So, Article 1, Section 8 lays out, in particular, the enumerated powers of the legislature. And the first thing it says is the Congress shall have power to lay and collect taxes, duties, imposts. So you see right off the bat, they have a lot of money-based powers, right? So I'm not going to go too far into that. But I want you to have burned into your head right off the bat that Article 1, Section 8 is a big deal for the legislative branch. And so within it, since it is enumerated, one of the things that the next cases that we'll look at states that Article 1, Section 8, it lists these powers, right? Like a roadmap. And it lists those that are necessary and proper to carry them out. So the powers that are necessary and proper for the legislature to carry out these powers. And all the other powers that aren't listed are supposed to be left to the states. Okay, so that should ring a bell in terms of what we kind of touched on the first week with federalism. And a lot of you answered in your first week's discussion. So without further ado, the 10th Amendment. The 10th Amendment is the definition of federalism. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. Meaning, if a power is not given to the federal government, it's our power, right? Again, the founding fathers were so concerned with a government structure that would mimic a monarchy that this was part of their solution. They said, look, we don't want a federal government to be an overarching authority. If there is something that is not provided to the federal government, it should be we the people's power, right? So again, just another echo of their concern. Which brings me to McCulloch versus Maryland. I love this case. It is great, 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 great. And I know you guys are going to get sick of me saying that, but it is a great case. So if you look again in a legal dictionary for federalism, you will see this case. And in your notes, if you're taking notes, I want you to put federalism =, McCulloch v. Maryland. Anytime in your analysis, notes, whatever, that you even sneeze the word federalism, it needs to have a reference to McCulloch, period, the end. So, federalism, again, it's just a shared power. It's a balance of power between a federal level of government and the state level of government. But that wasn't always so. Again, none of this was always solidified. We had to start somewhere in terms of understanding our limits, understanding what powers went to who. And so one of those powers dealt with money and, of course, banking. And in 1816, the Congress passed a law to incorporate a national bank, right? So not a private bank. It wasn't like Capital One or anything like that. It was a national bank, right? And they have the power to do this. Again, Article 1, Section 8, they have the power to make money, regulate it. In other words, they have the power to decide how to do things that deal with money. And so they thought the best way to do this is to set up this national bank and go set up shop in states throughout the United States and issue money in order to make it more uniform. And I'm going to make my face big again. So remember, after the Revolutionary War, when, spoiler alert, we beat, the king, we were not united. There was nothing united about our country at all. Again, there was almost a civil war between the states before the Civil War that we all know, right? And it was between Pennsylvania and Connecticut. And it was over the lack of unified money, of currency. Some states had pounds, some states had francs, some states, I'm trying to think of had what other currencies. But in essence, there was no uniformity at all. And that was a big problem. And so this was one of the solutions is to have this national bank that put out this uniform type of money so that everybody was on the same page, right? So with that being said, the first one that they set up was in Philadelphia. And I want you to commit that to memory. There was already one in Philadelphia, and everything was hunky dory in Philadelphia. Everybody was like, yay, this is great. Okay. I mean, I don't know if they really said that, but it seems like they would. Then the trouble brewed when they opened up in Maryland. So McCulloch, who was the bank manager, opened up in Maryland, and everything was going okay when they first opened until Maryland was like, why are you in our state? We didn't ask you to come here. Absolutely not. So they actually tried to tax them out of the state. They taxed them at an absolutely exorbitant rate with the specific intent of running them out of the state. They said they did not want a national bank in their state. They thought it was a federalist kind of oversight, overarching power in their state that made them a little nervous. And so they wanted them the heck out of their state. And so the president of the bank, though, McCulloch, he said, screw you, I'm not paying your state tax. We have every right in the United States to be here. We have an Article 1, Section 8 power to be in your state. So it was a Wild West showdown. Now, remember John Marshall? Y'all remember John Marshall, right? Good old John Marshall. I love John Marshall. He's just fun, and you'll understand why I think he's fun. Okay, so John Marshall comes back in the story. He's still Supreme Court Justice, all that fun stuff. So I know this is odd, but this will help you remember. So anytime you guys see John Marshall as a justice in any case, I want you guys to know that the federal government is going to win. And I say that, and I've looked. There's not one case that he ever presided over in which the federal government did not win. Ta-da! So it's kind of funny, and I want to tell you a funny, quick story. When I was looking for this slide, when I was looking for the pictures, I was like, oh, this would be kind of funny if I found like an Arnold Schwarzenegger and been like, I want to pump you up. I know it's a terrible impression, and I apologize. But I was looking for the picture, and my colleague walked in on me when I was looking for these pictures and how I was Arnold Schwarzenegger, like, when he was in his wrestling days. And she looked at me, I was like, I'm not looking him up for any other reason as to, I just thought it'd be fun to put in my PowerPoint. And she's like, okay. And she just closed my door. I was like, great. Now I look like some weirdo. But anyway, it does fit. So anytime you see Marshall, I want you to instantly think he's going to pump up the federal government. And he does again and again and again. So without me even going to the next slide yet, who do you think is going to win? Maryland or McCulloch?
Maryland.
McCulloch.
So I hear Maryland and I hear McCulloch. I think whoever said Maryland might have been confused. So do you think the federal government, meaning McCulloch, who is the bank manager, is going to win? Or do you think the state of Maryland is going to win?
Bank manager.
Think.
Okay. I'm so excited. Dun, 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 dun. So the first argument that the Supreme Court, meaning Marshall, looked at was excuse me, that they heard was they said, well, look, the branches are doing their job. They set up the bank and there's precedent. So live with it. So pause. Where was the other bank that they're talking about?
Philly.
Good. So bingo. So remember, there's already a bank. So that's what the federal government is arguing. They're saying, look, we already did it in Philly and they're all good. So this isn't the first time we've done this. So that's their argument. Now, here's the federal government's second argument. They argue that they have ultimate sovereignty, that there's people in the state, they gave you the power to enact the Constitution, and the Constitution's supreme over the states, so the states do not have ultimate sovereignty. Now, in other words, Congress gets to determine what implied powers means as long as rational. Now, pause for a second. That kind of argument makes people cringe, and I want to reiterate or kind of simplify what that argument means. What they're saying is that you and me, everybody in the class, we all vote who our representatives are, right? Our senators, our House reps, all that, our Congress people. And so what the federal government is arguing is like, look, you're voting them in, and so the state really doesn't have a say so, because at this point, those people you voted in, they're your voice. So you kind of stopped having any say so once you voted those people in, because they're now your voice. So it made a lot of people a little nervous when they started arguing that, right? Then gets a little more wonky. Their last argument was the elastic clause. Now, this should be burned into your brains because it's still an argument made as of 2026. It is still cited in Supreme Court briefs. The elastic clause argues, in essence, that in order to execute previous powers, the Congress shall deem what is necessary and proper. So let me put this another way. When you have a rubber band, what does a rubber band do when I go like this? Whoop, let me go like this. Oh, there we go. What does a rubber band do when I pull it this way?
Stretches.
Expand.
It expands. It gets bigger, right? So what they're arguing is that, yes, they have all these enumerated powers in Article 1, Section 8, right? You guys saw them. They have a lot of money-based power. But they're saying in order to achieve that they can expand their powers in order to achieve these powers. So they can expand their powers, just like a rubber band, elastic rubber band. They can expand them in order to achieve all their money-based powers. So have more power. That's what that means. That convoluted little paragraph right there. That essentially means they can have more power because of the elastic clause, because they can need to achieve all their money-based powers, and not all of what their power is listed. So in order to achieve what they need to, they can expand their powers. And I need to move this way. They need to expand their powers just like a rubber band, right? That's what they're arguing. And what's even more interesting is they even argued, they said the intent of the founders was to allow an elastic clause to expand their powers, not limit it. In other words, John Marshall is saying that the founders wanted their powers to increase, that they never intended the powers of Congress, the legislature, the Article 1 powers to be limited, which I don't know, right? So this was a huge win for the national government. And in other words, it gave them the ability to decide how it wanted to do its job. It was a huge win for them. Because again, in Article 1, Section 8, there's nothing in there that says that they can open a bank. There's nothing in there that said that they can open a national bank. It does give them the power to make money, coin money, regulate money. But because of this interpretation by the Supreme Court, because of judicial review, they said, well, look, they can, because they need to achieve all this coining and regulating money, in order to achieve that, we can expand their powers, right, through the elastic clause, and allow them to do this in order to achieve their job. So again, this is a really good example, not just of congressional power, legislative power, but also judicial review. And then Whitney said that seems counterintuitive to why we broke away from Great Britain. And a lot of people had argued that. Absolutely. You're not wrong on that argument. And then pending acceptance. Okay. So then that brings me to the Interstate Commerce Clause. So the Interstate Commerce Clause is, again, Article 1, Section 8, but this time Clause 3. And this gives the ability of Congress the power to regulate not just money, but commerce, meaning money, with foreign nations and among the several states. So I'm going to show my face real quick. That means, in other words, like let's say this is a border between, let's say this side's Texas and this side's Louisiana. If I'm selling something between these two states, that instantly becomes federal territory. Why? Because I'm selling, that's commerce. I'm doing something dealing with money between two states. That opens the door to interstate commerce. If you're not doing anything outside of one state, if you're selling something just within one state and no other state is involved at all, that's called intrastate, and there's no federal involvement, just one state. But that's extremely rare, especially today. And I say that, look around you right now. And I mean that sincerely. Look around you right now. And I'm looking at my Dolly Parton mug, which is, by the way, isn't this great? Look around you right now at your cups, your pens, your shorts, whatever it is. Is anything you're wearing from your county or your state? And sadly, I'm looking around and nothing I have is from Texas. Well, I take that back. I have wooden chairs from Texas. So I say that to say very few things today are what would be considered intrastate. So this opens the door to federal regulation because most things that we deal with today pass state lines. And so most of them are interstate, meaning it opens the door to federal regulation. So with that being said, it brings us to Gibbons v. Ogden, which again, great case. All of these cases deal with fantastic human complex issues. And I will say this, it's 10 o'clock. I'm going a little bit over and I'm so sorry. So if you need to hop off, you will not hurt my feelings. But I'm picking up the pace, so I apologize for going a little bit over. But again, this is another John Marshall case. So before I go any further, any clue as to how he may rule?
With the government.
Yeah, he's gonna pump them up. I'm so sorry, guys. Y'all are gonna be like, Professor was doing horrible Arnold Schwarzenegger impressions today. But nonetheless, you're right, Etta. It's exactly right. You know, without any doubt, the federal government's gonna win. So the federal government is getting pretty beefy. The Interstate Commerce Clause is at issue. And I just explained to you the difference between interstate and intrastate. But this deals first and foremost with Fulton. And I guarantee you guys that every single one of you have learned about Fulton in some way, shape, or form, probably in elementary school. Does anybody recognize Fulton? Thanks, Ignacio. Don't Google it.
Paddle boat, steam engine.
Yes, that's exactly right. So Fulton was an interesting person. So Fulton, again, thank you for getting that. It's rare. Usually nobody knows. Invented the steamboat. But what's interesting about Fulton is they were kind of like his little group that he ran around with. I kind of envision him as like the original Bill Gates monopoly. You know how Bill Gates is associated with having like the Microsoft monopoly? So was Fulton. So Fulton invented the steamboat, of course. He teamed up with a man named Livingston. Okay, so it's Livingston and Fulton. They get a license to navigate rivers. Now, let me tell you what that meant. That meant that Livingston and Fulton owned everything, meaning if you wanted to navigate a river and make some money, you had to go through them. So not trying to make them seem like bad guys, but they're kind of like the riverboat mafia. I mean, you had to go through them in order to make any money, because they were the only ones that had that license. Nobody else, and I'm going to say that again, nobody else had one. So Ogden, he was actually the former New Jersey governor. He was not happy about that. He was like, that's baloney. And so he tried to fight the monopoly. But, you know, if you can't beat them, you join them, right? So he realized he was not going to win. And so he actually bought a franchise from Fulton. And he gets his best friend in the whole world, Gibbons, as a partner. Now, guys, should you ever go into business with your best friend?
If you don't want to be best friends again, sure.
That's right, Etta. That's exactly right. So I always picture, again, I have a crazy imagination, but I always picture Gibbons and his best friend. Yep, Billy said nope, and you're exactly right. I always picture them like they're at like a sleepover braiding each other's hair, and they're like, we're gonna be best friends forever. Let's open a business together. And they're like, wee, and they're so happy, right? But like all good friendships, it doesn't last. And what do you think broke up that friendship? Like most friendships, especially between men.
A woman or money.
A woman. I tell you, and her name was Sarah. And Sarah was supposed to be this ravishing beauty. And alas, but what's funny is she actually didn't end up with either one of them. She's like, yeah, peace out. I'm going with Billy over here, right? So she didn't go with either one of them. And but they fought really hard for Sarah's love. And they ended up having this huge fallout, right? And their business went kaplunk. And they break up. So he's like, I don't want to play with you anymore. I'm going to this side of the playground and you suck. And so no more business. So they did some really sneaky, crappy things to each other. Gibbons got really sneaky and he obtained a federal license from Congress to navigate the same river that Ogden got, navigating under his puny little state license, right? So again, Gibbons went through his little network and got a license that otherwise the only other two people in the entire United States that had that license were who? Do you guys remember? Fulton and Livingston. So now he's in this cool little triad of cool kids who have a federal license. And his old friend Ogden just still has his puny little state license. He has nothing else. So I think you guys know where this is headed, which is nowhere good. Remember, Congress has the ability to regulate trade amongst the foreign nations and several states. So here, the heart of the matter is who has the better license, the federal or the state one? Because of course, Ogden is saying, look, I have a state license. I'm staying in this one state. I'm, going up and down the river. I'm providing X and Y and Z goods. And this guy, he has his federal license, but I got mine first. And so mine should be better. And of course, Gibbons' argument is, yeah, that's cute, Ogden, but mine's federal. And so this is another side note. Webster, I tell you what, Gibbons really wanted to get his friend. I mean, talk about just bad blood. Webster was actually his attorney. Does anybody recognize that name?
From the dictionary?
Yes. He actually had the guy that wrote the dictionary as his attorney. I mean, mic drop. Can you imagine? Like your ex-best friend walks in and he's like, who's your attorney? Oh yeah, Webster, the guy who wrote the dictionary. I'd be like, yeah, I'm done. Good day, sir. So yeah, not a good look for poor Ogden. I mean, he probably knew from the start that he was not going to win. But nonetheless, Webster, who wrote the literal dictionary, argued for Gibbons, and needless to say, he argued something very literal and very definitive as per the definition of a river, which is a river flows. It does not stay within one state territory. The very definition of a river is that it flows between and among states. And so as a result, he was able to argue that the very nature of a river made it a federal-based entity that the federal government controls, not the state, right? As per Article 1, Section 8, Clause 3. And so Ogden knew that he was just dead in the water. Gibbons won hands down. And as an interesting side note, because the very year that this case came out, the South was really concerned with this case because they saw this as an opening for the federal government to also control them more because the infrastructure was being built more in the South, meaning specifically roads. And so, as a minor side note, just a historical side note, they were kind of pulling back a lot of their roads that went between states because they saw that case and they said, well, wait a minute, a road could be akin to a river, and we don't want that business in our neck of the woods. And so they actually kind of pull back on the road infrastructure because of this case. Just kind of a fun historical fact. So at the end, they ruled that it was necessary for the federal government to regulate waterways and that Gibbons ultimately won. So this case was the predominant case that defined federalism, defined the Article 1, Section 8 powers, and expanded yet again, John Marshall expanded federal power. Okay, so you're starting to see this pattern, I hope, of the federal power growing and growing and growing and growing. And poor Ogden, you got to feel bad for that guy. All right. And then we come to Prince. Now, Prince, 1997 case. I hope you guys noticed that year. It took this long for federal authority, as per Article 1, Section 8 powers, to limit that power. Think about that. That's a long, long, long time. And John Marshall has long been dead. So he's long gone. So no more pumping up power. And this is a big case. So let me hide my face so you guys can see the slide, because I never know how it shows up on y'all's end. But nonetheless, the court knew this was a big case because there is a method to their madness in terms of when they release their decisions. And they actually released this last as they're walking out the door to go on vacation. They didn't want to deal with the fallout because they knew it was going to be a big deal. But Brady, of course, was one of the individuals that was shot by, and some of you are too young to remember this, but Jodie Foster had a stalker. And her stalker thought that he could get her attention by assassinating the president of the United States. And back then, it was Ronald Reagan. So he tried to assassinate Ronald Reagan, did not, succeed. He shot at him, did not succeed at that, but he did end up shooting two other individuals, paralyzing one, killing the other. And as a result, Brady was the impetus, the motivation for the Brady Handgun Control Act. Now, with that background in mind, the 1993 Brady Handgun Control Prevention Act required a certain background check, okay, of individuals who wanted to buy a gun. Now, I want you to look at this background or these bullet points with me. Now, it required state and local officials, not federal, state and local officials versus the federal actors, like federal agencies, to conduct background checks. And then the sellers required to report pending sales to police chiefs, okay, not federal, but state or local, right, or local police chiefs, to conduct background checks. Now, there was a slew of lawsuits that were brought on because these police chiefs in particular said, look, this is unconstitutional. You can't make us engage in something that you, the federal government, want to do. If you guys want to do it, that's great, but you're just putting on our plate something that we shouldn't be compelled to do. And so the issue before the Supreme Court was, can Congress make state officials like police chiefs participate in the implementation of a federal program? Ultimately, the Supreme Court said, as per the 10th Amendment, Congress may not compel them. Now, Scalia, he has since passed, but was on oh, thank you, Dan. Dan said John Hinckley. Thank you. That was totally slipping my mind for some reason, but thank you. Scalia was on the court for many, many, many years, and he was the majority opinion writer. And he said there's no historical evidence that Congress could make state officials to implement federal programs. And otherwise, they're not saying that the program in and of itself is wrong. They're saying what's wrong about it is making police chiefs do something that the federal government itself wants to do, right? So let's take it a step further. Scalia said that this really was a concern to the court because they want the states to retain a lot of autonomy, meaning independence. And it kind of upset the balance of power between the federal and the states. And he said the federal power would increase if they could enlist officers of the 50 states to do this, right? Now, Congress cannot delegate power to state law enforcement officers. But as many things, guys, legally, there's always a loophole. And they said the states could voluntarily comply, but they just can't be forced. And so a lot of states during that time period were giving incentives, monetary incentives to participate, but they couldn't be forced, right? So they couldn't say, you have to do this. They would say, if you participate, you could get this amount of money or blah, blah, blah. But they couldn't be told that they had to do it. So that was the loophole. And it's mentioned in the decision. All right.
Was the reason that the police chiefs didn't want to do it was because of money? Like they would have to fund that?
Well, it
Or
wasn't just that, it was a lot, right? So it was resources and time. A lot of it was resources and time because that was a lot additional work on their plate. And the federal authorities, they had more resources to do those type of background checks, in a nutshell. But that's a great question.
Yeah, I would say basically it would have caused police chiefs to redirect resources and have to do that instead of fighting the problems in their local communities and whatever crime is specific to there. That's why, in my opinion, it's a good decision because by limiting that federal power of, hey, we're going to tell you how to use your time. That's, I think it said in there, the Anti-Commandeering Act or something.
Mhm. Yeah, a lot of police departments um are so small and they're like such resources. Um and I'll give you an example. There's one in Texas in particular that and it's not funny, but I was doing some research years ago and I was trying to determine how much crime was happening in this one county for a study I was doing. And when I called their department to see how many calls for service that they had, the police chief laughed and he was like, calls for service. He was like, we don't even have 911, ma'am. And I was just like, what? Like, and I said, how do people get help? And he's like, oh, they call my phone. And I'm like, what? Like, I didn't, and this was back in 2022, I think. And it just blew my mind. In terms of local resources, there are still some police departments that are still so small and underfunded. I can see where that would be a dilemma for some, in terms of putting that on their plate. But that's a great question.
Isn't that kind of illegal? Aren't these, wouldn't the federal government or the state government help them out with some kind of 911 funding or whatever?
No, 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 it's not illegal. There's a lot of police departments that are actually being disbanded right now because they don't have any resources. Coffee, Texas is one of them. They actually don't have a police department at all right now.
yeah, some are using county.
Mhm.
They're like they just skip over like even like the suburban areas of Chicago. There's
Yeah.
some money issues and they've just pretty much said, oh, the county responds
Yeah.
instead because they don't have anybody, two officers, etc.
Yeah, it's a big deal. Yeah, it's not a good situation, that's for sure. When he said, and not every population supports background checks, conflicts. Yeah, that's a good point too. That's a good point. I'm not going to touch that one with a 10-foot pole, Whitney. But yeah,
Can I ask the question? Can I
yeah.
ask the question? In regards to I consider it bribing. The federal government is going to bribe the state governments to
Mhm.
implement, whatever they want. So if the state governments have did that, accepted the money, and that's illegal, right? Accept the bribe, right?
It's a
Is that
gift.
no,
Or
Wait, you
no?
mean if they had accepted the money to conduct the background checks?
Yeah.
No, that's not
So
considered a bribe. It's the same thing with, let's just say,
More
when
of
the
an
drinking age went up.
incentivized.
Yeah, it's an incentive. So back a long, long time ago, when the drinking age went up, a lot of states actually fought that, and Louisiana being one, of course. And so they actually gave them the incentive of if you go up in your drinking age, we'll give you X amount of money. And so they actually were given additional funds for increasing their drinking age. I'm trying to think of other examples, but yeah, usually it's given as an incentive to fund different operations, different, yeah, it's an incentive. It's not a bribe.
okay. Thank you for the
Mhm.
clarification.
Yeah, absolutely. Brian said it's like a block grant. That's a good way. Oh, and then Whitney said, I remember the seatbelt laws, and that was a fun time with folks fighting that. Yeah, I mean, it's all granted. All right, so let's end with the Federalist Paper number 78, which is such a fantastic, good set of papers that I really hope that you guys have the opportunity to read them. Because to me, we talk about today, and I'm not really I'm actually not on social media at all. I'm on LinkedIn, but that's it. And it's not because I have anything against Facebook or anything like that. It's because if I am on it, I know I'll dive in that rabbit hole and I won't come out. So that's why I know myself. That's why I don't get in there. But humans have always had that tendency to go back and forth with one another. And the Federalist Papers are actually an example of an original like battle between individuals, right? It's an original battle between individuals who are having a disagreement, and it's in a fantastic discourse. So Federalist Paper is actually Alexander Hamilton. And so when I say, what is good old Hammy trying to say? That's who I'm referencing. So he's actually referencing and responding to Brutus, which I love that name, right? Brutus. So Brutus wrote an anti-Fed paper. And remember, at that time period, the theme was Federalist versus anti-Federalist. They were just going at each other like crazy, right? So not so much different than where we are today with, one group going after another group. Again, history has a funny way of repeating itself. And so at that time, they were going toe to toe, debating one another. And at that time, Brutus says the judiciary power lacks accountability and is too independent. The anti-feds are afraid if we get these guys in for life, they may impose their will over the Constitution. And then what do? So in other words, Brutus is saying, if we get these guys in this court-like situation, this supreme entity of a court system, we can never get them out. They will be in there for life, and they will be the supreme rulers in our society. And that was something that Brutus wrote in his papers, that was something we should all fear, was that they were going to be these all-powerful beings in our society. And he said, getting rid of a judge, not so easy. Now, Hamilton, he's kind of like the guy at a party who sees a fight. He's like, calm down, chill, guys, chill, right? And he says they don't have the power of the purse, they don't have the power of the sword, and they're the weakest of the branches. That was his argument. Now, he says they're men of virtue. You have to trust them. They create precedent and they create rules that we follow. So in other words, good old Hammy is saying, if not them, then who? And I think that's a kind of a valid argument. If we don't have a Supreme Court, then what? And he's not denying that there's issues, but he's saying there are limits to this branch. That was his response to Brutus. Now, Brutus doesn't buy it. Brutus is kind of like, whatever, Hammy. He says, are you kidding me? There's no power above them, no authority to remove them. And this is my favorite line. He says they're independent of the people, of the legislature, and every power under heaven. Wow. So then Hamilton says, we need judicial review. Early echo of Marbury. And he says, we need someone to do it. If not them, then who? So he said, ultimately, trust is vital amongst the branches. We need to honor their word because they serve as somewhat of a guard against tyranny, right? So they're that guard against what our founding fathers were so fearful of, meaning us, because he was a founding father, which is having another monarchy. They're that gate. They're the guard that prevent us from having another king. That was his response to Brutus. Now, with that being said, this week, you guys have that assignment. I ended with that Federalist Paper 78 because I want you to keep in mind that after all those cases, where do you stand? Do you think they're the weakest? Do you think they're the most powerful? What do those cases say to you? How did you feel after hearing those cases? What stands out? What, moving forward, did you think that they served in the means that they should have, right? So again, there's no right or wrong answers. We care about how you got to your ultimate answer, right? Again, not trying to sound harsh, but we care about the path that you got there. So keep in mind the 100-word limit. We don't care how you split it up. If you want to do 50 for part one, 50 for part two, that's great. But if you want to split it up a little different, that's fine too. I'm trying to think of anything else. Be confident in your writing. Try to avoid first person, like I think, or I believe, or I advise. Just state what you advise. Be confident. If you think they're the weakest branch or whatever, say the judicial branch is the weakest because, boom, right? Come out of the gate with your position. Don't conclude with it. Try to include references, meaning a case. You don't have to throw them all in there. Last term I had somebody that tried to include every single case that we went through. Don't do that. Try to use the case or cases in a way that strengthens your argument in a way that makes sense. Trying to think of anything else. I'm forgetting anything else.
How do you, so in the response part of the discussions, so like let's say instead of saying I agree, I know you're saying like state your position, like I get that part. But how are we actually like so if we disagree, just say just what we think and not a comparison. Like, like
Are you saying
I
if you
don't know.
disagree with like a classmate?
Yes, right.
Oh yeah,
Like,
yeah.
like in the
You can
discussion.
use. Sorry, I didn't mean to interrupt you.
I- oh no, 'cause we don't.
Sorry, it kind of cut off a little bit. Can you hear me?
Yeah,
Okay.
you can't hear me.
It got kind of wonky there for a second. Sorry. For the classmate responses, you can use first person and you can just say, I respectfully disagree, or I understand your point, but I also thought blah, but yeah, you can use first person for your classmate responses all day. Just not for your initial response. Thanks for asking that. I didn't think about that. But yeah, for your initial response, try to stay away from first person. But for your classmate responses, you can say, I thought, or I, blah, 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 whatever. Does that make sense? Okay, good. Any other questions or anything? Or jokes?
Can you can remind us, do case references and constitutional references count against the word count?
No, they don't. I don't count them against y'all. So if you guys reference the Constitution or a case name, I don't count that towards your word count.
Okay, thank you.
Yeah,
I have a question.
sure, Wanda.
Um, I know that you said that it has to be 50 words total between the two questions, but it appears that we have 3 questions in this one.
No, it's 100 words total. So
So
it's a,
even with the 3 questions, it's just 100 words total?
hold on. So let me go back up to it. Hold on. So for part one, you select one from part one, and then you select part one from part two. So you're answering in total 2 questions.
Okay,
So
I'm
you,
so sorry.
oh
I'm
no,
so
don't
sorry.
apologize. No,
Okay.
don't apologize. No, I'm glad you're asking me these questions. That's
Mhm.
don't ever apologize for asking questions, guys. No, you have 3 options from part one, and you have 3 options from part two, but you just have to choose one from each. So in
Okay.
total, 2 questions.
All right, thank you.
Yeah, absolutely. And then I see I have a chat. And do case references and constitutional references count against word total? No, they don't. Any other questions, guys? Or I could just look at you awkwardly.
Count in what way? So if we say, if we're citing it like in the United States Constitution versus like putting it in parentheses. So in the parentheses, it wouldn't count, but does it count when you state in the United States Constitution?
No, I'm not going to count that. So either
Okay.
way, like if you say
Okay.
in Article 1, Section 8, Clause 3, I'm not going to count that. And if you put in the parentheses, I'm not going to count that. I hope that made y'all feel a little better. All right, guys, I'm about to sign off. I don't know why my room in here is like freezing. These Girl Scout cookie boxes, I think, are blocking my heater. I'm gonna set them on fire so I can heat up. All right, guys, well, have a wonderful day. If you have any questions, just, let me know. I'm here for y'all. And have a great time digging into the material because they're fun cases. And I hope that this lecture kind of helped you better understand the context behind them. So if you have any questions, let me know. All right. Bye, guys.